Hi, this is Frederick Scott Smith. Should we change the United States Supreme Court? Set up as a co-equal partner of government, the judiciary has the shortest description compared to the legislative and executive branches. While Congress establishes much about the judicial branch, one characteristic meant to elevate the court from politics but has become increasingly intertwined with partisanship is fixed in the Constitution. Article 3, Section 1 of the Constitution states that judges of the Supreme and inferior courts shall hold their offices during good behavior. Supreme Court justices may keep their seats for life unless impeached and removed or leave the bench voluntarily. Alexander Hamilton argued in Federalist 78 that a judiciary, separate from politics, could keep the other branches from unconstitutional actions. Stephen Johnson Field retired from the U.S. Supreme Court on December 1, 1897, after serving 34 years as an Associate Justice. His age and declining health may have influenced his decision to retire. Oliver Wendell Holmes, Jr. retired from the Supreme Court on January 12, 1932 at 90. He served on the court for 30 years. William Douglas retired at 76 on November 12, 1975, after serving for over 36 years as an Associate Justice. Pressure possibly arose after suffering a stroke and paralysis. Ruth Bader Ginsburg had a history of health problems, including multiple bouts of cancer, but remained active on the Supreme Court until shortly before her death on September 18, 2020. The nomination of her replacement faced delay from an opposition Senate, and as a result, a justice from the other party filled the seat. Ethics issues also arise and are not resolved during long-time appointments, as critics charge Clarence Thomas has familial connections to political controversies, and has sometimes not disclosed financial matters. With the increasing political importance of the court and presidents nominating younger candidates, a rising percentage of potential justices may stay in office for 3 or more decades. Changing the language of the Constitution involves a difficult amendment process. The Supreme Court operates within the framework of the Constitution, and its own rules primarily determine its procedures. However, potential changes in the appointment process or term limits for justices could alter how the court operates. Additionally, the court could hear more cases or use different methods to settle disputes. Congress could restrict the types of cases brought before the court. Legislation could also change the size of the court. Throughout history, the number of justices has ranged from 5 to 10. Congress or the Supreme Court could strengthen ethics and transparency of proceedings. But would the legislature then impeach and remove justices for violating such changes? The Supreme Court could operate like one of the appeals courts, wherein a small allotment of random justices could hear a case, for instance 3, and the selection changes for each case afterward. That may also increase the number of cases heard. With political games increasing when replacing justices and public confidence in the court declining, a call for reform is in the air. However, today it is mostly coming from Democrats. During the supposed liberal heyday of the Warren Court, conservatives were calling for the impeachment of the Chief Justice. Perhaps reform is necessary or only appears when the shoe is on the other foot. I'm Frederick Scott Smith. Have a good day. I know I will.